They said she was not able to pay her bills. They suspected she had dementia, and her agent was no longer available to pay her bills, which were about $10,000 a month. Let's see. Let me click this off so I'm back on the screen. Okay. They suspected she had a dementia, and there was no alternate agent named in her power of attorney. Now, I had seen Ruth, and this is a true story, but Ruth is not her real name. I had seen Ruth, I hadn't seen her in over 10 years. So my question to you, and we're going to bring Ruth back into this presentation throughout the presentation and give you the end of the story, the rest of the story at the end. But my question to you is, when was the last time you reviewed your estate plan? Or had your parents review their estate plan? If there's a crisis such as a stroke, a heart attack, onset dementia, and your loved one or you ended up in the hospital or a nursing home, are the legal documents up to date? Is your power of attorney up to date? So proper preparation in advance gives you the best chance of retaining control in the future. So on the next slide, we have a picture of a hurricane. Now, we all know how to prepare for a hurricane. Hi, Lori, are you still on?
Yeah, and I'm having a little trouble sharing my slides, so.
Okay, well, anyway, we have a slide of a hurricane, and we know how to prepare for a hurricane, but are we prepared for a medical crisis that renders us incapacitated? We know that if we wait until the last minute, we risk losing control. So during the next 45 minutes, we're going to try to help you make a list so that you can get all your ducks in a row. So on the next slide, what does it mean to be incapacitated by dementia? On the next slide, let me get back to my client, Ruth, for a minute. And if you go on to the next slide, Lori, we told Ruth, we were told that Ruth had dementia. And when I went out to visit her, even though she hadn't been officially diagnosed, she seemed confused. She didn't remember who I was. She was having difficulty hearing me. I had to talk very slow and very loudly so that she could comprehend what I was saying. She was in a wheelchair, and she was not able to care for herself. Now, she could talk, but her hearing seemed impaired and she did seem confused. So moving on to the next slide, we've got both cognitive incapacity and physical incapacity, and combinations of both. Now, with cognitive incapacity, if you're not, basically with cognitive incapacity, if you've seen one, you've seen one. You've probably all heard that expression before, because each case is different. Each situation is different. You can't have stereotypes when you're dealing with cognitive incapacity. The brain has many different functions, and the diseases of the brain affect different parts of the brain at different times and in different order. There's nothing that you can say that makes it a stereotype type of situation. Each situation has to be dealt with individually. Each case is unique and each case is different. So in the next paragraph, when we talk about having legal capacity is the capacity to have the ability to understand the consequences of your actions and to be able to make rational decisions. And of course, just the converse is true. To not have legal capacity is to not have the ability to understand the consequences of your actions and to not be able to make rational decisions. So in the next slide, for estate planning purposes, such as a will, a trust, a power of attorney, there are basically three requirements. So if we go to the next slide, Lori, I think we maybe have trouble switching our slides. Let's see, where are we? The sooner planning starts, the more the person with dementia may be able to participate. So if we back up one slide, well, no, let's stay there. For estate planning, such as a will, a trust, or a power of attorney, there are basically three requirements. The first requirement is that you know what you own, at least generally. So what we ask when we're talking to a client, do you own a home? Do you have money in the bank? About how much do you have? Do you have investments? What we're trying to get to is, does the person have a concept, an understanding of what it is that they own? We're looking to establish capacity to make a will or a power of attorney or a trust. So the second question is whether they know who the natural objects of their bounty are. So we ask questions like, tell me about your family. How many children do you have? Do you have grandchildren? Do you have brothers and sisters? Do they have children? And if you're giving to charities regularly, who are you giving to? Because we want to come up with the third question, which is that they have a reason for the plan of distribution that they want to make in the will. They have a rational plan. Why do you want to leave so-and-so out of your will? They've always been in your will in the past. So we're looking for a reason. Now, so in the next paragraph, or the next slide, even if a person has mild dementia, they still may be able to participate in the planning. The sooner the planning starts, the more they're able to participate and retain some level of control, over their future. Once cognitive capacity is lost, however, a person's ability to make documents such as a will, a power of attorney, or a trust, that capacity gets lost. There comes a time when cognitive capacity is sufficiently diminished that a person is no longer able to participate. Back to Ruth, when I visited Ruth, it did not appear to me that she had legal cognitive capacity. She didn't remember who I was. She seemed confused. She didn't seem to hear or understand what I was talking about when I spoke to her. So on to the next slide. If a person doesn't have a will, the state of Hawaii has a law which provides a will for them. And basically, there are two ways that assets are transferred if a person dies without a will. The first way is what we call will substitutes. A will substitute identifies the beneficiaries. A will substitute avoids probate and does take priority over a will. So examples of a will substitute might be a joint tenancy. You're all aware of joint tenancy bank accounts. There could be joint tenancy in real estate. There could be joint tenancy in ownership of securities. When one of the joint tenants dies, it automatically goes to the other. It doesn't matter what the will says. It avoids probate and it goes to the other joint tenant. So we've had situations where a person might have a will that says, upon my death, I leave everything to my 3 children in equal shares. But it turns out that all of their investments or their bank accounts were held with one child as a joint tenant. Well, that one child gets everything that was held in joint tenancy. It doesn't get divided equally. The joint tenancy takes priority over the will. There's another type of will substitute, and that's called a payable on death account. We call it a POD, payable on death account. That's where you go to the bank and you tell them that you want a beneficiary designated on your account. So when the loved one or when the person dies, the account automatically goes to the person designated as beneficiary without going through probate, and that supersedes the will. It doesn't matter what the will says, the payable on death account takes priority. And of course, this is the same also with other types of will substitutes such as an IRA. You name a beneficiary of your IRA, of your pension plan. You name a beneficiary of your life insurance. That beneficiary will inherit basically that IRA or that life insurance, and it doesn't go through probate. And it doesn't matter what the will says, the beneficiary that's designated in the life insurance or IRA or pension will take. And then another very popular way of avoiding probate and providing for beneficiaries is to have a revocable living trust. So you have a revocable living trust, the assets in the revocable living trust will pass to the beneficiaries designated in the trust. Now, so those are will substitutes. But there's another way of transferring assets, assets that are not in a trust, that are not beneficiary designated, that are not in joint tenancy, and there is no will. Those assets will pass by the Hawaii will, the law of intestacy. The legislature got together and decided who they thought most people would want to get their property when they died. And if they didn't have a will, the legislature came up with a will for that person. It's called the law of intestacy. It's rather complex. It depends on whether children from former marriages or and so forth, but it does provide what the legislature thinks most people would want to have done. So if we move on to the next slide, when there's no power of attorney or there's no trust, then it may be necessary for the court to appoint a conservator to manage and protect the assets of the individual. Now you can avoid the cost and delay of a conservatorship proceeding by having a power of attorney or having your assets in a revocable trust. In our situation, getting back to Ruth, Ruth had a power of attorney and she had a trust. The problem was that the agent under the power of attorney and the successor trustee under the trust was no longer capable of acting on her behalf. The agent had become incapacitated and there was no alternate named in the document. So that's a planning pointer. Make sure when you do a trust or a power of attorney and you name an agent that you have an alternate in case that agent is unable to act. On the next slide, we talk about the Advanced Healthcare Directive. An Advanced Healthcare Directive is a combination basically of a power of attorney for medical care and a living will for end-of-life decisions. In the Advanced Healthcare Directive, you can designate the level of life support that you want at the end of your life. Whether you want to be kept on life support, whether you want to have artificial feeding or hydration, and so forth. Now, the level of life support at the end of your life, if you can't communicate that because of your incapacity, then you should have filled out a document in advance, such as an Advanced Healthcare Directive or a document we call Your Way, which I'm going to talk about a little bit later, which communicates your preferences. So that's a planning point, is to make sure those are in place. In the next slide, we talk about if a crisis occurs and you and your family are not prepared, you face confusion, uncertainty, and panic. And it's kind of like being on the freeway. You're late for an appointment, your GPS is out of order, and the directions are in the trunk, and you don't know which exit to take. Well, what happens when that happens, you enter in what we call the long-term care maze. This is what Lori went through some 20 years ago with her parents.
Yes, I went through this with my mom, who at the age of 80 had a major stroke. And while she was in rehab and the care team was talking to me about where she should be discharged to, I, trying to be a good daughter, thought, well, we'll bring her home. I could take care of her. And I frankly had really no idea what I was signing up for. She was disabled on the right side of her body and had to relearn how to walk. I brought her home and had almost a disastrous first month trying to adjust to caring for her, caring for our 3-year-old daughter, the household, and my business. And I became, as a result, very ill, and was confused and overwhelmed by this whole experience. I'm not one to say, oh, help, help. I'm like a lot of you who don't want to ask for help, but I was down for the count and I realized I had to ask for help. The problem was, where do you get help? How do you start? How do you choose? What caregiver should you use? How do you determine that they're good? How are you going to pay for it? This is all a mystery to most of us who are thrust into the long-term care maze and who have not considered this ahead of time. So if your loved one has been diagnosed with Alzheimer's, consider starting the planning process as early as possible.
So how do you prepare for these major decisions? These decisions include, first of all, who's going to care for your loved one? Or if it's you're making the plan for, who's going to care for you? Is it going to be a family member? Is it going to be a sibling? Is it going to be your spouse, a paid professional that comes in? And then you need to consider and make a decision on how will long-term care be paid for. Do you have sufficient private resources, investments? Do you have long-term care insurance? Do you have, are you going to prepare for the possibility that you would run out of money and need Medicaid? How about using the equity of your home? How will long-term care be paid? And then the next decision is who will make the financial or medical decisions if you can't make them yourself. So we move on to the next slide and we talk about the two primary goals that should be right in the front, the first and second goals, and that's providing maximum quality of life for both your loved one and for you. If you have a serious a setback in your own health and you're caring for a loved one, who then is going to step in and take your place? So one of the major efforts is to make sure that the caregiver is properly cared for, so that they can continue to provide the quality of care for their loved one. And then how is this done? On the next slide, we suggest 3 areas to plan. Plan for the legal documents, make sure they're all in order and in place and kept up to date. Plan for the financial, understand what the financial assets are and keep those in track, and plan for the future financial needs, building a budget, for example, and then planning for the personal needs. So in the next paragraph, or the next slide, we talk about putting together a team that can be flexible with pre-crisis planning and focus on building support systems, learning new communication skills, and increasing personal safety. Now, communication skills becomes very important. There are a number of courses that are held. AARP sponsors several very good courses on communicating with a person that has dementia, and learning the skills of how to communicate and how to effectively talk with a person that has dementia becomes a very important thing. And also increasing personal safety becomes very important. We want to make sure the home is safe. One of the big ways that a person enters into the long-term care maze, so to speak, is through a fall. So we want to have proper things in place at home in order to avoid the possibility of a fall. For example, grab bars strategically located, getting rid of throw rugs so there aren't trip hazards where a person's going to trip and end up in a fall and end up breaking something, and then the long-term care maze starts oftentimes. So moving to the next slide, we want to have assemble a holistic team of advisors and navigators, financial advisors, legal advisors, and elder care coordinators, persons that can coordinate and navigate the healthcare system. So we start with the elder care attorney. You should hire an elder law attorney to help you organize, customize, and update your legal documents. Now, one document that's very important is the power of attorney. Back in 2014, the Hawaii legislature adopted the Uniform Power of Attorney Act. If your power of attorney was done before that, you should have it brought up to date. And you should review the selection of the agent under your power of attorney. Is that agent available? Is that agent stable? Is that agent financially competent, trustworthy? And then with the power of attorney, you have what oftentimes the elder law attorney will do is put certain advanced, enhanced provisions into the power of attorney that are specially designed for seniors and to maintain Medicaid qualification. And then a power of attorney, we recommend a power of attorney have a provision requiring the agent to account to other family members to safeguard against exploitation, and also so that there is a full transparency. We strongly urge, if it's a family member that's acting as the agent under a power of attorney, to provide quarterly accountings to the other family members, so everybody's kept up to speed on what's going on. And we even provide a separate template to the agent so that the agent can have a format on which to prepare that accounting. Now, another document that should be in place is the Advanced Healthcare Directive. We supplement the Advanced Healthcare Directive with a form that you can fill out called Your Way. The Your Way form has hypothetical questions that the person can answer so that you will know what kind of care they want in the end of life situation. It's got places for comments. It's got a lot of places to include information so you're fully prepared if your loved one ends up in an end of life situation. The kind of music they want, the kind of it kind of reminds me that I was talking with Lori about this, and she says, I think I want to have somebody cooking bacon. And she may not be able to eat the bacon, but she liked the smell of bacon. And I thought, yeah, and I'd like to have somebody put a sign over my hospital bed that says, I can hear you. Because apparently that's one of the last things to go is hearing. Well, you can get the Your Way supplement online. I'll tell you where to go. Go to www.helpforseniors.org. Now I'll spell it for you. So if you got a pencil, write this down. HELP numerical 4 SRS.org. Help for Seniors, spelled SRS.org. You can go there, you can get a free Your Way supplement that you can use. I find this a very valuable document. Now, you may have other documents you use, quality of life statements. The 5 wishes is one that is used often to indicate what you want to have happen in end of life situations. The last document on this list of documents here includes a revocable trust. Well, the purpose of a revocable living trust is to manage your assets if you become incapacitated. That's one of the purposes. Of course, another purpose is to pass assets upon your death without going through probate. But during your lifetime, if you become incapacitated, the revocable living trust is a great tool for managing your assets during that period of time. The power of attorney and the revocable trust work together for that purpose. Now, what you should have, what the elder law attorney should do is expand the incapacity clause in the power of attorney to spell out more clearly the authority of the trustee to provide you with a higher level of care if you're incapacitated. For example, if your intention is to stay at home, you may write that into the trust agreement and also provide that the trustee, the successor trustee, has the authority to make adaptive modifications to your home, to hire caregivers, to provide you with a higher quality of care at home and be able to use trust resources for that purpose. We want that specifically authorized in the trust so that other family members that may have a disagreement do not object to your using the money that they consider to be their inheritance, to using the money to provide the best quality care at home by hiring good quality caregivers and enough of them to make sure that the job is done correctly and properly. If you needed to reside in an assisted living facility or even eventually perhaps in a nursing home, we want the power of attorney to authorize the successor trustee to be able to pay for a private room, to hire a personal care attendant to assist. So if we go to the next slide, your attorney should also provide an ongoing maintenance program. So for example, getting back to Ruth, if Ruth had been part of a maintenance program, then 10 years wouldn't have gone by without us being in touch with her. Now, a maintenance program involves monitoring your estate plan and your finances over time. What we want to do is make sure that we know what the assets are, so that accounts can be easily located in case of a crisis. If there's a trust, we want to make sure that the trust is fully funded. We want to look at the account statements and check to make sure that the accounts and the investments and so forth have all been placed into the trust, the real estate and so forth have all been retitled into the name of the trust, so it can be fully managed by the trustee. We want to make sure that beneficiary designations on things such as IRAs, pension plans, and life insurance are consistent with the estate plan. The estate plan, if the overall plan of the client is to leave everything equally to the 3 children, we want to make sure that the life insurance doesn't then name one of the children, but all 3 of the children as beneficiaries, for example. The same with the IRA. So we look at beneficiary designations. We want to make sure that emergency funds are in place. We want to make sure that all legal documents are kept up to date. So your elder law attorney should be periodically reviewing the estate plan to make sure that documents are up to date, that if an agent has become ill or moved away and another agent would be more appropriate under the power of attorney or the advanced healthcare directive or the trust, that changes are made in a timely fashion to designate the new agent that should be in place. And we want to make sure that the agent continues to be capable and know what to do in the case of an emergency. So this would be a kind of a continuing monitoring maintenance program that is prepared. Next slide.
Just a clarifying question from Carmen.
Sure.
She's wondering if she does an advanced care plan through Medicare, since it's it's part of her primary care physician benefit. If she does that, how does she integrate that with an attorney, an elder law attorney? Do you have to create a new one, or can she use one that's already been created?
Now, this is a plan that she has with her primary care physician.
Yeah, she's saying that since Medicare allows for advanced care planning, how can you coordinate that with an elder care attorney? Do you just hand over the document, or do you have to do another one?
No, I think what
Kokoamau, they offer a lot of workshops on how to do your advanced directive. So how does it work?
Well, the primary care physician becomes part of the team, of course, in an elder law practice. So the documents or the planning that the primary care physician has done is incorporated into the planning that the attorney does, so that they're both working on the same page and coming up with the proper plan in place. Because the primary care physician is looking primarily at medical care, long-term care, the kind of maybe living arrangements, the kind of medical care that should be planned for the future based on the prognosis of the client. The client has dementia, or the client has other Parkinson's disease or other kinds of disability. The primary care physician knows how these disabilities progress and makes plans for those in a document. But that's then used by the elder law attorney and the elder care coordinator that works in the attorney's office to be able to fit all the pieces together. If the person needs to be moved to another facility, one that could provide the kind of care that the primary care physician envisions in their plan, well, that facility should be vetted and properly looked at it to make sure that it's the kind of facility that can provide that kind of care. And so the attorney's office and the elder care coordinator would work with the primary care physician to make sure that the person is moved into an appropriate new location if that is necessary, or if it's going to be home care, that the persons coming in are vetted and are properly trained in the kind of care that's needed for this particular, prognosis. So it all works together. The primary care physician becomes one of the team members, so to speak, of the elder care attorney's long-term care team. When we talked about assembling a holistic team of advisors and navigators, I mentioned several, but I may have neglected to mention also the primary care physician is part of that team of advisors. And so we all work together. I hope that helps answer the question. We want to, let's see. Yeah, we've built the maintenance program. One of the things we do in the elder law practice is to evaluate potential future eligibility for Medicaid assistance and planning to steps to consider to prepare for that. Sometimes we have clients that it appears that, with 24/7 care at home or with assisted living, that there's a potential for running out of money. And so we want to develop a plan that addresses that. So that if a person does run out of money, that Medicaid assistance would be available. And one way we do that is we consider Medicaid Asset Protection Trust, into which assets could be transferred that instead of having certain assets spent for the nursing home, the assets are transferred into a trust that can subsequently then be distributed to trusted family members who can use those assets to enhance the care of our client when they're in a nursing home. And yet the client would be qualified to have Medicaid pay for the nursing home and then get enhanced care from the Medicaid qualified trust or from the beneficiaries of the Medicaid qualified trust. Now, this is a way of planning for the future so that assets are preserved or set aside that do not disqualify our client from Medicaid, but can be used to enhance their care at the nursing home, get a private room, for example, or a personal care attendant. So there are a lot of different ways that we can plan for the future so that a client can get better quality care and still be able to qualify for Medicaid and preserve some of the assets to pay for Medicaid, to supplement Medicaid, and then still be able to provide perhaps an inheritance for their children when they pass on.
I'm going to jump in here and just add that the Medicaid program doesn't cover certain types of expenses. Dental care, seeing a podiatrist, vision, eyeglasses, a lot of that is not covered by Medicaid. So having these assets set aside to supplement care means that care in those areas not provided for by the Medicaid program can be provided. You're not going to have to rely upon a family member to be out of pocket to pay for the dental appointment or the new eyeglasses. The next person to consider adding, in addition to the elder law attorney and the primary care provider, is an elder care coordinator. And what is an elder care coordinator? Well, this is somebody with a non-legal background who might have had a lot of field experience in geriatric nursing or perhaps social work. And their focus is on helping find the right care for your loved one from reputable care providers in the community, based upon a very complete assessment that they do initially. This is we call it a quality of life assessment. And it includes a lot of areas, including the person's health, their cognitive capacity, their environment. What does their home environment look like? How safe is it? Their opportunities for socialization. People get depressed and go downhill rapidly if they're isolated in their homes. It's almost like they become a prisoner in their own home because they don't have an opportunity to see and talk to other people. Family dynamics is important. And of course, family support is very important. And as you can imagine, each of these is an important part of the assessment because they may bear on whether or not care can be provided in the home, and if that's realistic, and is it in the best interest of the person who needs the care. So what does, in addition to all of that, the assessment, what does the elder care coordinator do then? Well, they will consider what helpful resources can be offered to this person. Resources from the community, resources, technological resources, all kinds of opportunities for help out there that can supplement what the family is doing. Last year with COVID, we had a lot of people in assisted living communities or in nursing homes who suddenly found themselves locked down as an infection control regulation to keep COVID from entering a lot of the places where there were a lot of vulnerable people. And as a result, many, many people became terribly depressed and despondent because they couldn't see their families anymore. So our elder care coordinator worked with a lot of these families to get a very simple tablet designed for people who have very little technology knowledge. It's called the GrandPad. Set it up in advance and send it into the facility so that they can see and talk to their loved ones every day if they want to. They've got an opportunity, a way to share pictures and a way to keep in touch during a difficult time. And this is very helpful because some of the communities eventually came around to offering a once a week FaceTime appointment for residents, but once a week isn't often enough for some families. That's an example of a technological resource. A community resource, which you may have already considered for one of your own family members, is maybe a grandma living alone at home, is a adult day program. There are a lot of good adult day programs out there, and having your loved one attend maybe a couple of times a week, maybe every day, where they have the opportunity to be around other people, socialize, engage in activities, have a hot meal. That can do a lot for a person's well-being. That's an example of a community resource. There's a definite need for the elder care coordinator to understand your loved one's baseline or current state of health. And that is an ongoing process, but it's done initially through the assessment and then updated over time. The elder care coordinator's role is also to educate the family, to help them support and care for the loved one with dementia. So the elder care coordinator, we call them the ECC, often will talk about how to improve communication skills, There are techniques that can improve communication skills that Tom referred to, how to handle behavioral issues, and remedies for caregiver burnout, safety issues, and they may routinely answer questions like, why isn't my dad eating? Or how do I stop my grandma from driving? Or how can I help my mom be happier? I have to tell you, as an aside, one of our geriatrician colleagues routinely tells families, sing with your loved one. That always makes them happier. That's a tip that you might want to consider. When problems do crop up in, whether it's in an assisted living facility, a nursing home, or even at home, it can be challenging for a family member to intervene to try to fix it without concern that that may affect the care that their loved one receives. You don't want to have to worry that if you complain about something, that are they going to take it out on mom when I'm not around? And this is a delicate situation. So having an elder care coordinator be able to step in for you and speak for your loved one to fix a problem. Now the complaint is coming from an outside professional, not from a son or a daughter. And there's no fear that sometimes the son or the daughter is considered overly emotional. None of that. Now you have the outside professional evaluating, asking for something to be fixed, and all the negativity from that potential communication by the son or daughter is deflected onto the third party professional. Having this person speak up for you is very valuable. And the care going forward then is monitored by the elder care coordinator, who will check in regularly, see the elder as well as the family to determine if the care needs have changed and make adjustments to the recommendations going forward. This means the elder care coordinator is continually updating that assessment, updating the recommendations, and when there are decisions to be made, the elder care coordinator is there to help make good decisions with the family. So for instance, we had a 90-something-year-old single lady living alone in her home with dementia, no children. Her niece discovered she was eating moldy food and was very, very concerned. And we had to have a conversation about whether her auntie was safe at home alone with dementia when she had lost the ability to discern that the food had turned bad. And it became an extended conversation with our elder care coordinator, helping her eventually see that this wasn't about the promise the niece had made to auntie that I'll never put you in a nursing home, we'll always take care of you. It shouldn't be about that. It should be about making sure auntie was safe wherever she was going to live, that she was safe and sound. And eventually the niece let go of this promise and the guilt that she felt, realizing that she did need to help her auntie be safe. So that is, in a nutshell, what the elder care coordinator does. We think of the elder care coordinator as a care coach, somebody who is there for the family, somebody is there for the loved one throughout the long-term care journey.
So the next step is to consider and to figure out how you're going to pay for the care. Memory care especially can be quite expensive. Bring Ruth back in. Remember Ruth? This is actually what generated the call to our office. Her agent under the power of attorney was no longer available, could no longer pay the bills of the assisted living facility. There was no alternate named under the power of attorney, and Ruth appeared to lack capacity to pay her own bills. Now, at that time, we had just hired our first elder care coordinator. This was a nurse named Sue. What she did is she offered to go and visit Ruth, talk to her care providers, her primary care physician, and see if she could come up with some suggestions. My thought as an attorney, when I came back to my office after meeting with Ruth, was, well, I guess the only thing we can do is go to court and have a conservator appointed. But fortunately, we had an elder care coordinator at that time that said, well, let me go out and take a look at this. So we'll get back to Ruth in a minute, but in the next slide, we put some possible options in providing and preparing for the need for financial resources. One is to have a cash reserve. This could be a joint bank account with a trusted child, or you could name the child as an agent on an account with the bank, a payable on death account, as an agent. The purpose being to pay bills. This account could be funded with maybe up to 6 months of anticipated bills, so that if there's a crisis and you're no longer able to pay your own bills, you've got a fund available that'll cover the bill paying for a period of time, and a trusted child as a joint owner on the account. One of the reasons we suggest a joint account is because it doesn't terminate at death. So it can be used to pay for funeral and other bills until a death certificate is obtained, and the successor trustee can step in and take over the management of that. But an alternative would be to use an agency account, but an agency account terminates at death. A power of attorney terminates at death. So that's why we suggest perhaps having a joint account that does not terminate at death, with a certain amount of money in it that can be used as a cash reserve. Another source of another option for paying for long-term care would be a reverse mortgage. I have a reverse mortgage. It's dormant for now. I don't draw on it. It just sits there in the back shelf, but I can draw on the equity of my home anytime I want for emergencies or for long-term care. So I use it as kind of a backup plan in case I needed it. Hopefully I'll never need it, but if I did, it's there. I can sit down and write a check on the equity of my home. You could also do that with a line of credit or a HELOC, but the problem there is you draw the money out and then you have to pay the interest as you're going along. With the reverse mortgage, you don't have to pay anything on it until you either move out of the house or die, or sell the house, and that's when the mortgage gets paid. So another possible option would be long-term care insurance. Now, if you have long-term care insurance, be sure you understand when it kicks in. We were recently hired by a client, and immediately Lori reviewed his long-term care insurance policy and found that he had missed 2 years worth of coverage for his disabled wife. Well, that was water under the bridge. He was not able to recover that, but had he understood the terms of his long-term care insurance policy, he could have saved substantial money in paying for his wife's long-term care, because she was one of the beneficiaries under that policy. I think we'll go on to the next slide. So you create a financial summary or inventory, and this assists the agent under your loved one's power of attorney, so that if you're in a crisis and an agent needs to step in and take over and manage your assets for you until you recover, it's good that you have available to that agent a financial summary or inventory, and that the agent then will be able to step in and manage the bills seamlessly without having to wonder where the assets are and where the accounts are, and it's all prepared in advance and available to the agent when the time arises. So next, Lori's going to talk about some more tips on being prepared.
So what we've been talking about are what you can do to create a team, to get a team started to guide you through a lot of the areas that you're unfamiliar with. But there are things that you can do at home in your family as well to prepare early, which will help maximize your family members' quality of life. And one of the first most important things you can do is have a family meeting. And this should be not a one-time meeting, but a regular meeting where you start the conversation talking about what matters most to your loved one. It might be that they really want to stay at home with the family. It might be some folks want to have private time. They don't want to be bothered by all the kids running around. Other people may say, well, I just don't want to be a burden. You need to have a conversation about what's important to that person and what brings them joy. Is it for some, maybe the companionship of their dog? Is it that's important to them? Maybe working in their garden every day. Maybe it's seeing the grandkids on Sundays. These are the kinds of things you need to talk about so that everybody knows what's important and prioritizes those items. Part of this should be a discussion of who has been asked to be the financial and medical agents for this loved one. Who are they? Are they well suited? Are they willing, able? Are they committed to carrying out this responsibility? They may need to be part of this conversation to help them understand what this may involve. And then have a realistic discussion about options for care. By realistic, I mean that who's going to care for your loved one? If there is an assumption that the adult daughter is going to move home, leave her job, her 2- and 8-year-old kids, her husband, move home and become your full-time caregiver, well, that just simply may not be realistic. Maybe it'll happen, but you have to think clearly about what the possibilities are. Who's going to participate as well? Because we never want to see it put on one person's shoulders. Everybody can contribute in some way to helping with care. For people who don't have family close by, you may want to consider hiring a professional fiduciary to act for you in the event that you're going to need it in the future. You should start early to interview them. Once you find one that is the right fit, that you feel good about, meet with them yearly, get to know them, let them get to know you, and build that relationship. And this is going to be important because at some point they may have to make decisions for you. You want to make sure that they're going to make decisions that align with your priorities. And the only way that's going to happen is if they know you. And then, of course, this is very important, create a backup plan. This is so often neglected, and frankly, it puts the loved one at risk. So many of us depend upon one person alone. I was the person for my mom, thinking I could do it all, but it is just not sustainable for one person to provide 24/7 care for someone who needs supervision. And sooner or later, the caregiver is going to get sick, is going to perhaps in some cases even pass away. It's very, very well documented in numerous studies that primary caregivers without support are at far higher risk of becoming ill and possibly even dying before the person they're caring for. So don't be in that situation. Create a backup plan early. Also, create a medical inventory. This could be an old-fashioned 3-ring binder where you keep copies of medical records, such as the summaries you get at the end of medical appointments, a list of the doctors, contact information, the caregivers, if you use family caregivers or a caregiver agency, an updated list of medications. If there's long-term care insurance, we usually suggest keeping a copy of the annual benefit statement with your medical inventory so that you won't forget, like that gentleman that Tom just mentioned, that he had this coverage and that it could kick in at some point. and make copies of your loved one's medical insurance cards, their Medicare card, if they have an Advantage plan, or if they've got a Medicare supplement plan, their drug plan, all that. Make copies of both sides of the cards and keep this all together. You may think this is unnecessary because you have a system and you know where all this information is, but if only you can access it and you do become ill, the person that has to step into your shoes is going to really appreciate your having had the forethought to put it together in a place where they can access it. This is the old school approach, having that binder, keeping it right there on hand. But there are all kinds of apps available now. They're popping up, new ones popping up all the time that can manage all of this information for you in a way that is secure and in a way that can be shared with perhaps the agent under the Advanced Healthcare Directive or other family members, the backup caregivers. Some of these apps you may have heard of: Caring Bridge, Care Zone. There's one called MetaSafe. There's a lot out there. You should check that out because it might simplify your life to have that app available and the information available right there in your phone. But if that's too much, go old school and make that binder. Also, create what happened? Oh, I lost my financial inventory page. Create a financial inventory as well. You want to have your assets listed, your financial accounts, copies of your bank and brokerage statements, maybe the yearly tax assessment you get on your real property. Keep a list of regular income, pension, Social Security, all the money's coming in. If there's rentals, maybe the rental income, and a list of regular expenses that your loved one has to pay. And this is going to be helpful to the financial agent at some point who may need to access the money to pay for care. And don't forget the things like valuable art collections or jewelry or coin collections. These sometimes get put in the safe deposit box, or they're in a box in the closet in the back in the dark somewhere, and nobody's thought about them. Get them out, take photos of everything, and note where they're stored. If at some point you believe that you may have to consider some kind of assistance from a government program like Medicaid or the VA aid and attendance program, you should consider starting to gather the records that are going to be required to apply early. The Medicaid long-term care program can ask for financial records going back 5 years. And I don't know about you, but I'd have a problem finding 5 years worth of records in my home files. I try to get rid of old stuff, and that could be a problem. Then you've got to go to the bank. Better to just keep a file, and in the event you have to apply, you've made the process a lot easier. The same thing for the VA aid and attendance. Now they have a 3-year look back period, and they have very strenuous documentation requirements. Don't forget about digital property. More of us, including folks in their 80s, have got some kind of digital account. Maybe it's online banking or a brokerage account that they manage online. Could be a social media account like Facebook, perhaps email accounts. A lot of people have accounts and they need to be planned for. And the old-fashioned way is to create a list of accounts and passwords and usernames. I now really advocate using a password manager, because for a very small amount of money, you can have a highly secure password manager that keeps all of this for you, and that you can share if you need to with perhaps a financial agent. You can download the information onto a flash drive or external hard drive periodically. I think that's probably a good idea. Store it in a safe place if you're ever worried that the website is going to go down. But for the most part, the idea is store all of this, make arrangements ahead of time with what should be done with these digital accounts, both once a person is incapacitated and after death. So all of this being said, these are all steps to take to help you prepare once a dementia diagnosis is received. And the idea, the goal, remember, is maximize quality of life. But doing this also will greatly reduce your loved one's anxiety and fear over the future. And it'll give the family a lot of peace of mind, because this is really a gift, this work that you do early. Most importantly, for your team of advisors that you put together early on, they're going to be able to respond immediately if, in case there is a devastating health event like a stroke or a bad fall. There's not going to be any downtime while people start from scratch to become acquainted with your loved one and all of the issues. You're going to have people ready to jump in and help right away.
And if you've been following our story about Ruth, let me give you the rest of the story. Our elder care coordinator visited Ruth at the assisted living facility. She reviewed her medications, thought she was being over-medicated for a lifelong epilepsy problem, and she talked with the PCP. And he agreed, and he redid the meds. And our elder care coordinator also found that no one had thought of changing the batteries on Ruth's hearing aids. So I then went to visit her again. And when I visited her the second time, she was lucid, she was cheerful. So, well, Tom, it's been many years. How are your daughters? She had cognitive capacity, and she was able to do a new power of attorney. Once more, and also in addition to that, we were able to move her to an arch in Pearl City with 5 other ladies about the same age as her who she bonded with, and we reduced the cost from $6,000 a month rather than $10,000 a month for her long-term care. So that's the rest of the story.
So by anticipating that storm called incapacity that's out there on the horizon, the goal is to avert disaster and maintain control. So if you take away anything from this talk, we want you to think about how important it is to start early and develop that relationship, an ongoing relationship with a team, attorney, doctor, elder care coordinator, perhaps a financial advisor, and family members that are all rallying around your loved one to make sure that they have the best quality of care. And be proactive, not reactive. When you're proactive and you're preparing early, you'll have a chance to take a few deep breaths and relax a little, knowing that you've done what you could to help your loved one have a good quality of life going forward. So, Jackie, that's what we have, but we have time for questions.
Sure. Can you stop your screen share?
Yes.
Or maybe I'll stop it for you. There you go. So Katrina was just wondering if you could reiterate, Lori, aside from the Caring Bridge site, what were the other online places that you suggested for summarizing important information?
Well, I know there's another one called Care Zone and another called MediSafe, but honestly, there are probably a dozen now. If you Google it, caregiver apps, you'll find any number of them, and um, some have a more medical focus. Others are more involved, are more focused on helping the family have access to the same information to help, bring everybody together for mom or dad or grandma.
Okay, great. Now, I want to invite people to feel free. If you have a question, you can unmute yourself by clicking on the microphone on the lower left part of your screen, or if you're on an iPad, it might be on the upper right. And you can ask your own question. If you could raise your hand, it would be great, but just go ahead. Or if you want me to ask it, please feel free to put it in the chat. I'll give you a second to think. Any questions out there? Okay, well, while people are thinking of their questions, I'll go ahead and put our evaluation up. If you don't mind just taking a moment to answer our evaluation, assuming I can do it. Let's see. Okay, so we've got an evaluation up. Did you learn something today that you can use? And was this a good use of your time? Oh, good. It looks like some questions are coming in too. And then overall, please do rate the session. Now, while people are filling that out, Joyce says, how do we start looking for ECCs? What is an ECC? Elder
Care communicator.
Elder care communicator.
Elder care
coordinator.
Coordinator.
Sometimes
Communicator
I have so
and
many
coordinator.
acronyms in my brain that I can't remember them all. So,
Right,
okay.
right.
So
So
her
you might-
question, how to start looking or where to start looking?
You might want to Google geriatric care manager. That's a more focused care coordinator position. But there are a number of caregiver agencies, those that have RN oversight. They have nurses on staff to keep an eye on the caregivers and the work that they're doing. They often have folks that can function as a care coordinator for older adults. Those are two good places to start.
Great, thank you so much. Do we have any other questions? I've somehow lost my screen there for a moment, but any other questions? Lorna is asking, is it possible to get a printed copy of the financial inventory suggestions that were mentioned?
Sure. I realized that when I loaded my PowerPoint, I loaded the wrong version, missing the financial inventory page. So
could you just send me a PDF of the whole thing and
Yeah.
I'll send it out with the recording?
I'll be happy to, sure.
That would be great. And then Faye is wondering, what is the general cost of an elder care attorney and an ECC? And I'm guessing that would be for specific functions. You can't really say what the cost is,
Yeah.
right? It would be for specific functions. So, yeah.
Well, we can give kind of a general thought, and Lori may want to add to this, is that some elder care attorneys will work on an hourly basis. And so depending on how much time it takes for the specific project, it's what it costs. Others will have a specific set fee for a specific set of documents. For example, to do a trust-centered estate plan, including a trust, will, power of attorney, short form trust, advanced healthcare directive, there might be a set fee. I've seen them range anywhere from $2,500 to $3,500, perhaps, for a set of estate planning documents. Although depending on the complexity of the client's assets, it could range up to 5,000 or more. Or I think you can go on Zoom, LegalZoom.com and spend $150 and get the documents, but you don't get the kind of advice to carry it out. Other attorneys will charge that's kind of like a flat fee. And sometimes an elder law attorney will charge a flat fee for a whole menu of things, because it's always been my thought that if a person knows they're going to pay, $150, $250, $300 an hour for your time, they're reluctant to call. And oftentimes those calls that aren't made are the serious ones that need to be addressed. And yet, because of the financial, the person won't call. And so some attorneys, I know that's the way we do, we come up with a flat fee at the beginning, and whatever it takes, then that's what we do. And sometimes we spend a lot more time than is actually being billed, because we want to make sure the job gets done right.
And that goes
other
back to
attorneys will-
communication. It is central. If there's not communication, then you can't get help. So that's why we believe in the flat fee.
Thank you. Yeah, I've seen a lot of people packaging a certain number of things for a flat fee. So any other questions? This is your chance, everybody. We've got some lawyers right here, not charging $200 an hour. It's your chance. Okay, well, if you think of it, I want to just show you guys one more screen, if I can pull it up. Oh, I've lost it perhaps. No, I've lost it. So on December 12th or December 10th, we will be doing a workshop with Kokua Mao on advanced care planning. And Hope Young is a fantastic presenter. It's free. I'll send the link to it in the next email where I send the recording for this one. But if you want to dive deeper into that aspect of this presentation, we have an opportunity coming up right away. But for now, I just really like to thank Tom and Lori for their time. And oops, it looks like we got one more question. I was too soon. So the question is, should a senior allow for paying an outstanding tax bill upon their death, or would that be covered? Hold on. Sorry. I don't know why I'm not seeing the rest of that question. Oh, wait. Oh, there's a couple questions. Should a senior allow for paying an outstanding tax bill? Can you see that, Lori? Upon their death, or would it be covered by their property sale? My dad is worried about getting, and then my dad is worried about getting life insurance to pay the IRS.
I don't see the question.
Scroll to the very bottom. So should her dad be getting life insurance to pay for outstanding taxes, or is that something to worry about?
Well, of course, I presume we're talking about income taxes, although oftentimes you see the purchase of life insurance in the context of estate taxes. Now, right now for the federal estate tax, each person has about $11 million exemption. And so unless the estate is over 11 million, we're not worried about estate taxes. Now, of course, that all may change under the current administration. There are tax bills in proposal that would reduce that 11 million to 5 million exemption. And I think there's a proposal to reduce it to 3 million exemption. So oftentimes in planning for the paying of estate taxes, if a person's estate exceeds the estate tax exemption currently of about 11.5 million, a purchase of life insurance in an irrevocable life insurance trust that can be used for that purpose is sometimes recommended, because the irrevocable life insurance trust keeps the life insurance from being subject to estate tax. So you're not contributing to the problem, because life insurance is subject to estate tax.
She's talking about
life
income
insurance,
tax.
you increase your tax. And so you want the life insurance held in a form that is not going to be subject to your estate tax. If the question involves income tax, the income tax liability is going to continue even after you die. And so one of the creditors of an estate, whether assets are in a trust or go through a probate estate, one of the creditors of the estate is the Internal Revenue Service. In fact, I think they're a priority creditor. They take priority over many other creditors to get paid. So if there are back income taxes that need to be paid, those will come out of the estate or the trust. And that may mean if there's no other assets but a home, it may need having to get a HELOC, with the heirs having to get a borrow against the home in order to come up with the money to pay the taxes. the income taxes. And of course,
Okay, and then another question is asking if they have a will and with designated beneficiaries, do they still need a trust?
it depends on whether they want to avoid probate of their assets. A will goes through probate. Assets in a revocable trust bypass probate. Probate can be time consuming and expensive. And so a trust may be valuable in avoiding probate of those assets when a person dies. But another reason for a trust is to manage assets if a person becomes incapacitated without needing court supervised conservatorship. Sometimes a sufficiently drawn power of attorney will substitute for a trust for the management of assets if a person is incapacitated. But by using a trust, you not only provide for the management of the assets during incapacity, but also the avoidance of probate at death.
And sometimes those, if you have two parents and one of them passes and then you go through probate and another, it's like it avoids a lot of going through that a lot of times, right? If you have a trust.
Yeah, you can avoid that. You can have a joint trust or husband and wife set up, and or each have their separate trust for tax planning purposes. It depends on the size of their estate. But let's assume a husband and wife have a joint trust. When one dies, the assets go to the other without going through probate. And when the second one dies, the assets go on to the designated beneficiaries, children or whoever, without going through probate.
Okay, so it looks like we're winding down on questions, but I have one myself that I'll ask because I know it's on people's minds. So I'm one of those people who I'm always afraid to call financial professionals, legal professionals, et cetera, because I'm worried that I'm going to end up paying a big bill for nothing, like just to talk, right? If I call, I'm going to end up paying a big bill. And so, do most people do a consultation with people before to tell them what they need to even think about purchasing, or how does that work? Like if the minute you make an appointment, you're going to have to pay one way or the other, or is there any cushion there?
I usually, oh, sorry,
ahead.
Tom. I was going to say, I usually get these calls, and it's important for us to be able to know that we're the right fit and that the client is the right fit both ways. So I spend a lot of time talking to people initially on the phone, first to determine if they're even a potential client, if there's somebody we can help. And we don't charge for that. That intake is part of the process that we use to help folks learn about what we do and help us learn about them to determine if we can actually be of service to them.
And
But
if I wanted to be super efficient when I called you, and I've got an older family member that I'm helping and they may have dementia or they may show early signs, what should I be asking you for? What would I say I'm looking for? Planning for dementia?
Yes.
Okay.
You're planning, you want to plan early.
And also, Lori has a whole series of questions she asks you.
Right.
And so if you don't think of the right questions to ask, she'll make sure that she asks you. So because there's a lot of information we would need to determine whether or not, as Lori says, this would be a good fit.
Yeah.
Got
and
it.
we don't charge for that. I mean, we spend a lot of time talking with folks, just like now, and giving information and answering questions without charging. So
Yeah.
Okay, great. So I want to just let folks in the audience know, because I see a couple questions asking specifically about their specific business, and we can't really promote a specific business, but you can always Google them and ask these questions yourself. But I do want to thank you, Tom and Lori, for your time and expertise. And for all of you caregivers on the webinar, I hope you had a great Thanksgiving. And if you're not joining us for advanced care planning, that you have a happy holiday season. And just know that we are so grateful that you spent the time with us in November, learning about different resources to help you on your caregiving journey. And we hope it was useful to you. I'll probably be getting out the webinar notes on Monday. So, or whenever Lori can get me that PDF, but thank you all and happy holidays. Bye-bye.
Thank you.
Bye, thank you.